Yes, Ms. Meeker.
Good afternoon, thank you. Just a very few short points, actually, that I'd like to take you to in the judgment of the district judge. If we can turn, please, to page 95.
Yes.
I'm only taking you here so you can see which section of the judgment it is that we've gone to. This is where the judge has put the subheading, is there evidence that the TAW agreements were granted with the intention of allowing the tenant to make any use of the property or giving them a role in its being brought back into use? So that was the question he was asking himself before assessing the evidence. And if you then turn to page 102, having reviewed all of the evidence and making some findings of fact, he then sets out what he says are the relevant findings to that part of his inquiry, if you like. And so he says, taking all of these findings into account, he's got various findings of fact here. In particular, I draw your attention to 7, the extensive renovations and demolition activities undermine any suggestion that STH would have been able to make use of the property. 8, the conduct of both parties is not consistent with someone intending to make use of the property. And finally, that Emeraldshaw's approach to the tenant's rights and obligations under the tenancy at will, and this was referenced to the lack of notice on termination, supports a conclusion that there was no intention to bring the property back into use and occupation in line with the purpose of the legislation. So he's gone through a very, very careful factual analysis of the evidence that he's heard, and he set out various findings, some of which, in particular, the extensive demolition and activities, are not, as I've already said, relevant to the facts in Hurstwood. So that's a factor that he himself, or it's a characteristic.
What was the evidence he had of that? Is it
the demolition?
As always, I've hoped for photographs, but there weren't. The photographs are of use by the
yes, we
charity.
We omitted really just
Right.
for the purpose of not giving you bundles and bundles of paper, all of the exhibits to the witness
But
statement.
he describes them as extensive renovations and demolition.
Yes, and there's reference to, you'll see that he makes reference to planning applications that talk about demolition. You have got the witness statement of Mr. Foster, Stephen Foster, who was the business rates manager. He gives some more detail about the planning applications, the dates, and what the planning applications were for. And basically, so the premises itself was made up of, if I remember rightly, offices and warehouse, and I think the offices were along the front and the warehouse sort of sat behind it. Yeah. There was quite significant, I can't remember if all or some of the offices themselves were demolished, and there was some rebuilding. I mean, it wasn't just renovation and it was demolition and of parts and renovation. And Mr. Foster's evidence says that there was fencing all around the site, just told to get in touch with the contractors if you wanted to gain access, etc.
Because that's quite a finding. It is a finding that subparagraph 7, extensive renovation, demolition, undermine any suggestion that STHY would be able to make use of the property.
Yes. Well, he quite clearly says in his judgment, he says these weren't, bits of repair work pursuant to section, pursuant to the repairing or the right of entry of the landlord. These weren't a lick of paint, I think, as he put it, or broken tile repair works. This was demolition, part demolition of the premises. Yes. Which, of course, in itself brings in health and safety requirements, defence sites, etc., etc.
The process. There's one thing is the physicality of what he's done to the building, but it's the process of doing it. Yeah. The people on site, the space they take, the scaffolding or whatever might have been involved.
But also the point that he accepted was that kind of work being undertaken, and there was no evidence at all that there was any discussion with Space to Help about it, or permission from them, or an agreement that them would be the most convenient. They just went ahead and did it. And that's absolutely inconsistent with the idea that Space to Help was the owner, that had the immediate entitlement to possession for the purposes of Section 65. That was the key point. So there he sets out very clearly the conclusions that he came to in that part of his judgment. So that's just one of the parts, which I say is material. If you look then to the next page, at page 103, this is another section where he deals with another question: who in reality had the practical ability to determine what happened to the property and could therefore be regarded as the owner? Who, in the words of Lord Denning, really had control over the letting of the property? And so he sets out his assessment of the evidence that he's heard. He talks about the tenancy at will agreement. He talks there about the history of the planning, the history and the planning at paragraph 126 as being just as important as the timing and the conduct of the parties. So again, he's referring to the fact that Emeraldshaw is making planning applications to do very substantial works to the premises, irrespective of space to help. He says at paragraph 130, the timeline and vision for the property, and of course that's the timeline and vision for the planning and the aspirations of the owner, which was to reconfigure this building into 4 separate rateable hereditaments in place of the 2 that had existed. He says the timeline and vision for the property is powerful and persuasive evidence that Emeraldshaw continued to treat this property entirely as its own, and not as if it had transferred a real and practical entitlement to possession to another party, entirely inconsistent with space to help being regarded as the tenant.
Finding effect.
Exactly. And on the next page, I'm not going to read you all of it because of course you can read it all for yourself. I'm just highlighting a few points. And he says on page 105 at paragraph 137, this of course is a holistic picture. So he's looking at everything in the round. He's not just picking on one specific thing that says this clearly falls foul of Hurstwood. He's saying it's a holistic picture. So he's looked at all of it. But if you then turn to page 108, this is the very end of the district judge's section on Rossendale. And it's crystal clear that he knows exactly what the ratio of Hurstwood was and what test he should be applying, or the way in which he should approach it in light of Hurstwood. Conclusion on the Hurstwood criteria, real and practical entitlement, which of course is the test. The Supreme Court decision in Hurstwood identified particular characteristics of rates mitigation schemes which might assist with a conclusion as to whether there was a real and practical entitlement to possession for the purposes of Section 65. And he says applying those, he calls them criteria, but it's quite clear that he just regards them as facets of or pieces of evidence, characteristics that might be relevant, applying those to the factual and evidential matrix of Emeraldshaw, and he reaches the following conclusions. And in my submission, that his conclusion in this case is unimpeachable. On the basis of the facts that he's found, the analysis that he's undertaken, he can't be criticised in my submission for drawing the conclusion that he did. He heard the evidence, he made the factual findings, as the judge said, as Judge Klein said, on the application for permission. There's no allegation of irrationality here, and that the judge wasn't right or couldn't sensibly come to the conclusions that he did on the evidence that was presented to him. So this isn't a challenge to his fact-finding process and the facts that he found. And just with that in mind, I think it would be helpful if we just briefly go back to His Honour Judge Klein's decision, which, if I can take you to page 61, please. And in terms of his assessment of the judge's approach to Hurstwood, that stems from paragraph 34 to paragraph 41. So that's the critical part of this judgment for your purposes. And it was suggested that the fact that he says the legal right had been confirmed for no purpose other than for the avoidance of liability for rates, in consequence of which the charity was not, but the claimant was the owner of the property, was somehow material to illustrating that even the judge had gone wrong on what the proper approach was. And it was suggested, I think, that he placed too much importance upon the rates mitigation factor, if you like, rather than the whole assessment that the judge made. But when you go on to read the rest of what he said, and again, it's another example of where you have to read all of it to see what he said. He says at paragraph 37, he says that the judge, of course, was uniquely placed to make the best assessment of the evidence. He says towards the end of paragraph 37 the extent of the building work and under whose control it was carried out, which effectively was a key and unimpeached finding insofar as accepting that the district judge had approached it in the correct manner. He did, however, go on to say which parts of the assessment he didn't agree with. So he has sat there and filtered through what the district judge has and hasn't found, and he says which parts he finds unconvincing. So at paragraph 38, for example, he says, I agree with the claimant, on the other hand, that the fact that a striking off notice or striking off notices may have been given doesn't automatically indicate the charity or any other company was or is dormant, etc., etc. He also agrees with the claimant that the fact that the charity is not registered is neither here nor there. So he's gone through very carefully and he's decided which parts he considers are supportable or are supported by the evidence and which are simply not relevant to the Hurstwood approach or the Rossendale approach. And so at paragraph 39 he says, I'm putting aside the two matters with which he didn't agree, and then he's gone and said why he thinks that the DJ did not go wrong. And so he sets out the various criteria, documents, so he thinks about the documents, what the DJ was entitled to conclude, and so on and so forth, and he eventually comes towards the end of that paragraph to say that the district judge was entitled to conclude that the charity had no real or practical ability to exercise its legal right to possession. So that's an entitlement to find that on the facts, not a legal finding, but a finding on the facts. And that right had been conferred for no purpose other than the avoidance of liability for rates. It's true that the present case can be distinguished from Hurstwood because there is no finding by the district judge that a particular regulatory regime was being abused, but it is no part of the ratio of Hurstwood, as I understand it, that such abuse must be found to exist. So he's absolutely right there. And he says that in the circumstances, he finds that it wasn't sufficiently arguable that the district judge made an error of law in relation to who was liable. And again, I say that conclusion was absolutely right in light of the judgment of the district judge. And it's that conclusion, which of course you have to look at the district judge's judgment to agree with it, but that conclusion was right, and in my submission is not a decision that should be overturned by this court. There are no grounds upon which to say that he went wrong in his assessment of that. Of course, the judgment in respect of Hurstwood or Rossendale is quite short in comparison to the judgment of the district judge, but you can see that he's cherry-picked out all of the relevant parts, the findings of the judge, and what he thinks is significant and what he thinks isn't. And even though he didn't agree with the judge on everything, he said that in the round, the judge's findings and his conclusion on real and practical ability to bring the property into use were absolutely unimpeachable. So I think I've probably said as much as I think I need to on ground A, unless you have any points you wish to raise with me.
Thank you very much.
Thank you. On ground B, I'm going to keep it very brief, because nothing's really been said on ground B. I've obviously put a short section in my skeleton argument about it, and it seems to me that from reading the judgment of His Honour Judge Klein, it seemed to me that what he was saying was that if the district judge had approached the question of sham on the basis that the interested party had the burden of proving sham, then that was absolutely right. He said if, and there was, I think I've made reference to the fact that I think that the paragraph numbers that he'd referred to were slightly wrong, but there was a point when he was talking about proving signatures on a document where he talked about the swinging burden of proof, and what Judge Klein said was that if that was the burden that he applied to the whole of the sham argument, he was wrong. But in my submission, when you read the judgment of the judge carefully, he is only referring to the swinging burden of proof about one specific factual, one evidential point. And then, of course, he goes on to say, but of course it wasn't necessary for him to make a finding anyway, so I'm not quite sure that we're very much the wiser about what his view really was on the judgment on sham, because he just says that it wasn't necessary for him to make that finding in any event. And so really it brings me to ground C, which I don't think there's anything between us. If you're with me on ground A, then ground C fails, as it must. If you're with me on ground A, ground B doesn't particularly matter. And that's where we find ourselves.
Thank you very much. Thank you very much.
Thank you.
Yes, Mr. Collins.
Very briefly, my lord. My learned friend took us to the trial Rossendale, which is His Honour Judge Cadwallader at tab 13 of the authorities. And the only reference that I would wish to just highlight is on page 256, which is once his lordship has considered, because I think, although it's not specified, he must have been sitting as a High Court judge. His lordship goes through various paragraphs of Rossendale, and in particular cites paragraphs 50 and 51 on page 256 and concludes, I therefore accept the defendant's submission that it is legally irrelevant whether PAG was motivated by a desire to avoid non-domestic rates. And that takes us back to the old section 46 Chestnut, which I would just go back to very briefly, if I may, on page 183 in Rossendale. Because, and I'm very grateful for Mr. Jackson's observation that these various headings were the ones, or these various points highlighted on the facts of Rossendale were the ones that the district judge took. But again, I think the real problem comes into the heading, which is relevant facts, but it is, we would say, no more than a distillation of the facts which were relevant to the Rossendale case. And when one looks at sub 2 on page 184, which is, I suppose, the one that we've been concentrating on the most, it didn't really matter where it was put in the list. It was put at the top of 184. It was put at the top of the list about avoiding liability for business rates, solely for the purpose of avoiding liability for business rates, because it sort of informs what then goes on thereafter. Because what is said in sub 3, the leases were not granted with the intention of allowing the SPV to make any use of the contrary to the property. To the contrary, it was an inherent part of the scheme that the SPV wouldn't have no ability to do so. And it could just as well have been put a little bit lower down the list as, they could have said, and the explanation for that is this was just purely about rates mitigation. I think where it's been put, with the reference to solely, has given it an elevation which it was not intended and which has been taken incorrectly.
You might say the same thing about factor 1 on the previous page. I mean, that, strictly speaking, is not relevant to the Rossendale question. It's background.
Well, that is exactly right.
This is, or put another way, context.
Yes, that's right. That's right. And that perhaps illustrates it even more. But it is the case, we would respectfully suggest, that this point about solely for the purpose of avoiding liability for business rates was something that was very much taken on board and as a really important consideration by the district judge, and really added to by the failure to understand paragraph 61 and to quote only part of it. My learned friend said, in relation to this when she made her submissions, that it was a sort of a prerequisite, because we wouldn't be having the discussion. A purpose of avoiding liability of business rates is a prerequisite because we wouldn't be having the discussion. But that can't be right, because on my grades of example in Felixstowe, example 1 was the intention was just to do a good deed which had the unexpected byproduct. The second was a mixed motive, and the third was a pure avoidance motive. But the finance officer just happened to get to Save the Children in. And in any case, none of it is relevant, except is Save the Children a real organisation? and is it able to take real and practical? Is it able to take real and practical entitlement to possession? Now, in this, my learned friend also went, going back for the penultimate time to the district judge's judgment, to page 91, to paragraph 91 of the district judge's judgment, on page 95 of the bundle. And it was what it said, and this is the beginning of the sort of factual analysis in relation to occupation. One part of which I then need to come on to answer my Lord Justice Holgate's point, which I promised to come back to. If you look at paragraph 91, the position of the respondent, 2 tenancies at will were granted, and then this interesting sentence. It was roundly submitted that the fact that the premises were not fully utilised, the respondent concedes that the evidence is sparse, but that's in the nature of the operation, doesn't mean that the intention to make use of the property was not there. Use of roundly submitted is interesting because that has with it, in my submission, a degree of disapprobation about it. And the plain fact is that if you were looking at this from a point of view of occupation, sparse evidence of occupation is absolutely fine, and that goes back to that 0.2% case. And of course, if you can have occupation within the meaning of section 43, ex hypothesi, you must be a person who is able to exercise, who has a real and practical ability to make use of the premises for the purposes of possession, because you couldn't even have sparse occupation in those circumstances. And that sort of takes us back to this great food event. And I think my submissions were all right, because the chronology is that the tenancies at will were entered into in June and November 2021. The periods which were being argued about for alleged rateable occupation were from June 21. There were 2 periods, but they span from June 21 to November 22. And I suppose there weren't any more because everything got slightly frozen in time while we had this terrific argument. And then the food event takes place on the 31st of July 2023. Now that's obviously after the periods about which we're arguing about rates mitigation in this case, after the notices that are sent out by the council. But my submission was that, and is, that the food event nevertheless is evidence, and it might only be sparse, it might only be 0.2% of the property, but it's evidence of occupation, which would suffice for section 43, and it's therefore evidence of real and practical ability, even though it's not within the relevant period, because real and practical ability, you don't just look at the relevant period of thing, you look at actually you look at the fact that, say, the Children Fund's been in operation for donkey's years, not just during the rateable period that it's in the Felixstowe warehouse. So we would say that that's something that should have been certainly put in the mix. And yes, it is true that His Honour Judge Klein has sort of put this to a sort of an irreducible minimum, whereby this is said to be not properly arguable. But we would say, taking into account those other points, and in particular that His Honour Judge Klein likewise places great emphasis on this point of rates mitigation. That means that we do here have a properly arguable case. So unless I can assist your ladyship and your lordship any further.
No, I don't think you can, but you have been of great assistance.
Well, we're very much.
We'll reserve our judgments and aim to produce them as quickly as we can. We'll circulate them on the usual basis to encourage you to spot the deliberate typographical errors which we'll sprinkle throughout, but not to re-argue the case. But can I say, and I think I speak for all 3 of us, if you are representatives of a tribe, it's clearly a most civilised tribe. We've very much enjoyed the clarity of your submissions, but also the way that they've been put to us, all 3 of you. And
Well,
so it makes the job altogether easier if the temperature is kept,
pay tribute
so
to
that we
Bernard
can concentrate on the
Fraser,
argument.
Jackson, and also to my instructing solicitors for putting the numbers.
No, well, that's
And
absolutely.
as I said, I'm much obliged to you, and thank you so much for those comments.
Thank you.
Court, I'm able